Fantastic. So the form I wanted to talk about today is going to revolve around arbitration. I've had some people ask questions about arbitration, and so I said, well, that's fine. Let's go talk about arbitration today. So arbitration is the fun form that you get to basically fill out every time. Arbitration 2121 form. Here we go. So arbitration. So arbitration, some people, and let me see here. Some people are going to think this is kind of funny. However, the requirement is you do not need the arbitration form signed or declined, right? You don't need to acknowledge that because every purchase agreement, the very last signature box is that. It is the acknowledgement of arbitration. Some real estate offices will say, well, I need that signed. And you can say, contractually, I'm not going to have my client sign something that means nothing. So no. I know like Edina Realty here in Alexandria, they're really sticklers on wanting that form in the file. And every time I talk to their broker and I say, listen, the form is not required. And he goes, yeah, I know, but it's a checkbox in our system. And I said, then fine, you can fill it out and have your client sign it. Big deal. If my client was interested in arbitration, I would have sent it over with the offer. So just recognize that you do not have to have arbitration signed. Unless they want to do it. Now, this long document here, which I'm not going to go through in great detail, but is really good homework for you, talks all about arbitration, right? Issue resolution and what they're doing, okay? And so this is the form that you can actually email and send to people, okay? Which comes from the National Center of Dispute Settlement, okay? So this is the party that the Minnesota Realtor Association, you and I have all agreed to by coming through on these. The form that you see, or you will see, if you decide to, or some of you maybe have, is this disclosure statement, arbitration disclosure in residential real property. So I'm going to add this form, and this is the one that I'm actually going to walk you through. And so this is the one that you maybe would have seen as you kind of walk through certain offers. Sometimes it'll come over, it'll be blank. Sometimes it'll come over, it'll be signed. Sometimes you maybe want to sign it and you want to go from there. So this is the arbitration form, right? So again, this 2-page document is nothing more than a disclosure. Okay, so there is a disclosure, and then the agreement comes down on the second page. So the arbitration disclosure here. So again, you sign it on a purchase agreement. You sign acknowledging that you have seen this form. So you do have a requirement to share this with your clients. You do have a requirement to be knowledgeable enough to talk about this. However, you are not an attorney. You are not licensed by the Minnesota Bar Association. And I say that because I know none of us are. So you can't really give legal advice outside of the realm of real estate as your license allows you to. So when we start with this thing, it states, obviously, you have the right to choose whether to have any disputes about disclosure of material facts affecting the use or enjoyment of the property that you are buying or selling, decided by binding arbitration or by a court of law. Okay, so those are the two options that you get to have right off the bat, right? So you can decide by binding arbitration, which is what this document does. It binds you, the seller and the buyer, together to agree to arbitration for any issues that may arise, or by a court of law, okay? So by agreeing to binding arbitration on line 5, this is the big thing that I tell people. If you agree to arbitration, nice and big and bold, you, Mrs. Buyer or seller, give up your right to go to claims, to go to court for claims over $15,000. Because what you're saying is you're going to allow arbitration to happen. So the big thing here is you talk about material fact, right? Anybody remember the statute of limitations on material fact? Kind of looking and watching. I'm guessing no. Okay. So your statute of limitations on material facts, can range anywhere from 2 to 7 years. Okay. On existing structures, it's 2 years, and then the 5 and 7 year mark come in when you start talking about wells and septic. So basically you have 2 years from the date of sale. So if somebody is able to find out that, well, you moved in the house in the winter, disclosures never said anything about, water in the basement, but they stained the concrete and they sealed it. It looks really good. It looks finished, right? But there was no use of that. And the neighbor walks over and says, well, hey, are you guys using the basement this time of year, right? Because we know the previous owners, they never used it in the springtime because there was too much water in it, right? Well, that's a material fact that wasn't disclosed, so you could go after somebody for potential damages, right? So maybe damage the sheetrock or damage who knows what. Mold grew behind the sheetrock because you didn't know to have a dehumidifier running and fans going or whatever, right? So the exponential growth of these issues can actually be pretty heavy. But you choosing arbitration, you're giving up your right to go to court for claims over $15,000. And if you've built anything recently, you know that $15,000 doesn't go very far. And so $15,000 is the limit to small claims court, or what sometimes they call conciliation court. But we call in the real world, we kind of call it small claims court. And so $15,000 is the maximum you can go after somebody in small claims court before you actually have to sue them, right? So that's why that $15,000 number exists. So, line 6, by signing the residential real property arbitration agreement, or this arbitration agreement, on page 2, you're agreeing to the following. Number 1, you're agreeing that disputes with demands which fall within the jurisdictional limits of conciliation court, again, that's that $15,000 limit, shall be resolved in the applicable conciliation court. So this says you are still able to take them to court for small claims issues, right? So the demands which fall within the jurisdictional limit of conciliation court shall be resolved in the applicable conciliation court or small claims court. So you can still take somebody's small claims if it's a $2,000 deal or a $5,000, anything up to $15,000. Once you get over that, then you're saying all other disputes, okay, so anything over that, and again, you got to remember, shall be resolved. Okay, so it's not an optional, it's not a can be resolved, it shall be. So anything below 15,000, you're automatically going to small claims court. Anything over that, you're going to take to arbitration. And the reason you would do that, again, is strictly because arbitration is going to be a little bit cheaper. Not always, but a little bit cheaper. Because if you actually sue somebody for a $40,000 issue, you're going to have some attorney fees and different things that come along with that. So that's where they talk about the value of arbitration. I'll tell you my opinion later on in the day. But all other disputes here on line 10 shall be subject to binding arbitration under the real property arbitration system administered by NCDS and endorsed by the Minnesota Association of Realtors. Okay, and that's that form that I just showed you that outlines all of those terms. The arbitration agreement is enforceable only if it is signed by all users. Okay, so that's got to be a fun one. We all like that one. If it is signed by all buyers, sellers, and licensees representing or assisting the buyers. Now, I will tell you, you as a realtor member with the Minnesota Association of Realtors have already agreed to arbitration. It's part of your agreement into the brotherhood and sisterhood of realtors. Okay, so you've already agreed that you would be involved in arbitration. That's how we handle commission disputes. We don't go to attorneys. We handle them through an arbiter. And oftentimes with our staff, our staff attorneys are oftentimes the arbiters for our internal stuff, primarily with commissions. So the arbitration agreement is not part of the purchase agreement. Okay, your purchase agreement will still be valid whether or not you sign the arbitration agreement. So again, this is not a condition. Anyway, stock language, it is not a condition of the purchase agreement. Now, if you had somebody who was really adamant and said, well, I don't want to sell my house to somebody who's not willing to sign arbitration, then you can certainly write in, this purchase agreement is subject to or is contingent upon buyer and seller both agreeing to use arbitration in the event that any issues arise, right? So you could put language like that in there as a condition. However, our stock language would not have you say that arbitration is a requirement or a term of your purchase agreement. Okay. Any questions so far? All right, seeing none, we're going to move on. Line 16, the arbitration system is a private dispute resolution system offered as an alternative to the court system. It is not government sponsored. NCDS and MAR jointly adopt the rules that govern the arbitration system. NCDS and MAR, we actually call it MAR, not MNAR now, so are not affiliated. Under the arbitration agreement, you must use the arbitration services of NCDS. So again, you are agreeing to utilizing the National Center for Dispute Settlement. Highly recognized. It's a national organization. Not a problem if that's what you want to do. Line 19. All disputes about relating to disclosure of material facts affecting the use and enjoyment of property, excluding disputes related to title issues, are subject to arbitration under the arbitration agreement. So if you have a title issue, which should be found prior to, in the event that it is not found prior to closing, that's when you would go back to the title company, work on your title insurance policy if it was granted and paid for, or work with the title company to resolve it and say, why was this not found prior to? And then you might have an option to sue them and do some other things along the way. Rarely does that happen, thankfully, so that's good. However, this includes claims of fraud, misrepresentation, warranty, and negligence. So my example of talking about how, they have a really nice finished basement, they advertise it as such, and, stained concrete is pretty acceptable as a finished material these days. So it very well could be, but, they do that because then they don't have to replace the carpet and so on and so forth. So that would be one of those situations of misrepresentation or potentially fraud if you could prove that they were purposely trying to withhold it from you. So nothing in this agreement limits other rights you may have under Minnesota Statute 327A. Okay, so that's new home warranties. Okay, if you're ever interested, you can look that up at the reviser's website. Or under private contracts for warranty coverage. So if you have like a home warranty plan attached to the house, this would not cover anything underneath that as well. An agreement to arbitrate does not prevent a party from contacting the Minnesota Department of Commerce, the state agency that regulates the real estate profession, about license compliance law. So this section here is basically letting you know that just because you agree to arbitration doesn't mean that you, the agent, are off the hook if you did something bad. Okay, so they can still go to the Department of Commerce and they can still go after you, file a complaint, which could affect your license and ability to sell real estate in the great state of Minnesota. Okay. Now, the next section here down at the bottom, the administration fee for the arbitration system varies depending upon the amount of the claim, but it is more than initial court filing fees. So again, you even have to remember that even to start arbitration costs more than going to small claims court. Okay, small claims court, you can usually get in and do the filing for less than $200 if you do it yourself. It's a pretty simple form. However, again, you are not an attorney, so you're not going to do this for your client, right? You can say, you can go to the courthouse and you can file right there with somebody, with the court administrator, and they can take care of it, or you can hire an attorney to draft the small claims court filing. But usually, I think it's like $120, $125, somewhere around there, at least in Douglas County, and it does vary. However, in some cases, small claims court or conciliation court is cheaper than arbitration. Last one I heard anyway, to even file arbitration was about $700. So even just to open the file with an arbiter with NCDS is about $700 in order to get that up and running. That was the last one I heard about. Maybe that was I don't know the dollar amount if it's related to that or not, but that was a pretty big jump in my book. The maximum claim allowed in conciliation court is $15,000. We already talked about that. This amount is subject to future change. That's a state statute change. In some cases, it's quicker and less expensive to arbitrate disputes than go to court. 100% it is true. But the time to file your claim and pre-hearing discovery rights are limited. Okay, so in small claims court, you have a smaller window of time, right? Statute of limitations that you can go arbitration. You agree to basically to the life that you own the property. The right to appeal an arbitrator's award is very limited compared to the right to appeal a decision in court. Now, this to me is the big kicker right here, because what this means is if you don't like the arbiter, right? If you don't like the arbitration guy or gal who shows up and they have a thing against you because you cut your hair short or you're a blonde and, his wife just left him who was a blonde or whatever dumb reason, right? The arbiter shows up, and if they had a bad day and you just by appearance or you trigger something or whatever, they could decide they don't like you, right? Because sometimes we have bad days, we make bad decisions. Well, the arbiter, here's your side, here's the other person's side. and then they alone solely make the decision on what's going to happen, right? So if it's a $25,000 claim, let's say, and they say, well, you know what, I'm going to grant this, you have to pay all $25,000. They could say, you're both kind of in the wrong here. Why don't you take 50% of the blame and you take 50% of the blame here, right? So the arbiter can decide that. Usually they don't split it. Usually it's kind of an all or a nothing type thing. However, I have seen a couple where they've split. But once the arbiter makes their decision, that's it. Like, you're not going back, you're not appealing it, you're not doing anything, versus the court system. At least the court system allows you to file an appeal and see if you can reopen that case, right? So you get the option, if you don't like the outcome, you get the option to try again. Maybe the judge was having a bad day. Maybe you missed a really important piece of evidence that came up during, the trial, so to speak, or the hearing. And then, there's all these opportunities to appeal that decision, versus in an arbitration setup, it's kind of a one and done situation. And that for me is the big kicker as to why I'm not a big fan of arbitration, because it's a one and done. Is it cheaper? No, not usually, not if you do it yourself. And you don't get the opportunity to appeal it. So, I mean, I'm not an attorney. I don't know. I just, from my logical brain, it would tell me that, and I put that together, arbitration doesn't seem like a win-win, right? It seems like it's easy. It is definitely easy. I will give you that. So there is value in that. However, it's not always the best solution for the client. And that's where you got to have that conversation to really understand. So let's see here. Line 29, I'm going to scroll down here. All right. So line 30, a request for arbitration must be filed within 24 months of the date of closing on the property. That's that 2-year, that's a Minnesota statute, 2 years on the, our material fact disclosure. You have a 2-year statute of limitations. So it must be filed within 24 months of the date of closing on the property, or else the claim cannot be pursued, which is pretty standard anyways, right? Now, if you can prove fraud, the court or the arbiter may extend the 24-month limitation to a larger period. So it kind of depends upon what it is and what you can prove. If they come, and this is the hard part because it's mostly he said, she said, but like in my situation, if the neighbor came over and said, oh, well, they knew that, the past 12 years that they lived there, but they never disclosed it, as long as you can get the neighbor, to testify to that, then you actually have something that you can hold up. Okay. Line 33, a party who wants to arbitrate a dispute files a demand. Okay, that's what they call it, is a demand to dispute, along with the appropriate administration fee with NCDS. NDCS notifies the other party who may file a response. NCDS works with the parties to select and appoint an arbiter to hear and decide the dispute. Sometimes you get a 3-arbiter panel will be appointed instead of a single arbiter. And most of the ones I've seen, it's only been a single arbiter at the request of the parties. So you may, again, if you have somebody who does it, you got to decide is a 3-person better or a single person. The party requesting a panel must pay an additional fee if you go to 3 instead of 1. And arbiters have backgrounds in law, real estate, architecture, engineering, construction, other related fields. So these are not attorneys. They're not, they could be, I suppose. However, oftentimes you become licensed by NCDS as an arbiter in a field that you have expertise in, and then you do that as a second income, a retiree job, that kind of a thing that you can move forward with. So arbitration hearings are usually held at the home site, meaning if it was, something happened in Crosby, and with a property there, it's probably going to happen that the arbiter is going to travel to Crosby and they're going to find a meeting location, and away we go. Parties are notified about the hearing at least 14 days in advance. A party may be represented by a lawyer at the hearing at their own expense. Naturally, you can always do that if he or she gives 5 days notice to the other party and to NCDS. They just want to know that somebody else is coming, right? Each party may present evidence, including document or testimony by witnesses, i.e. the neighbor. The arbiter must take any award within 30 days from the final hearing date. So they have basically a 30-day window to make their decision, take the facts in, absorb, process, and then decide the award. And the award must be in writing and may provide any remedy the arbiter considers just and equitable. That's within the scope of the party's agreement. So again, the arbiter considers just and equitable. So you're allowing one person or potentially 3 people to decide the entire outcome. And again, sometimes these are pretty small. That's why you go to small claims court. You can do it one-on-one. Some of them are big deals. The biggest one I heard about was $140,000 as it related to a foundation issue. That's a big deal, right? Jacking the house up, redoing the foundation, setting the house back down because the guy failed to mention that the house kept sinking in one corner, right? The arbiter does not have to make findings of fact that explain the reason for granting or denying the award. Basically, he submits his letter in writing that says, we're gonna, the seller is going to pay all of the demands on this, or all the award, right? And that's it. There's no, this is why we think this is because of this, this, and this, and this. Nope, it's just a simple letter that says this is who's going to pay the amount of the award. We find this to be fair or just and equitable, and then they move on. The arbiter may require the party who does not prevail to pay the administration fee as well. So if you demand or file, the word they use is demand, but if you file for arbitration and you lose, you could still have to pay the full administration fee. This arbitration disclosure provides only a general description of the arbitration system and a general overview. For specific information regarding the admin fee, please see the fee schedule and the NCDS rules. Copies of the arbitration agreement if you want to call there. And if you have any questions, please call NCDS at the 800 number or consult your lawyer. Now, so ncdsusa.org, ncdsusa.org. Let's see if we can find the fee schedule really quick. Dispute resolution. Let's go real property. Iowa Realtor. I'm just going to see if we can find the fee schedule really quick. Where can I get forms? How long does the project? Attorney? What is it? Let's go fee. I'm just going to see if we can find it just out of curiosity. Minnesota real property arbitration fees provided these rules. Anybody see the fee schedule? Iowa. Minnesota real, here you go. 2018, they haven't changed. Okay, so here you go. So if you have a two-party case and you're looking for a single arbiter and your claim is $3,000, a decision and documents only, it's $250. If you want to have, it's under $300,000, you want an oral hearing, it's $650. And then, so it does vary depending upon how much restitution you're seeking, right? So, I mean, check this out. If you got a large thing over 50 grand, the initial filing fee and you only want a single arbiter, you're going to pay $2,000. But if you're that heavy, you're probably going to say, probably like a 3-panel member, you're going to pay $3,700 just to file this thing, right? And this is a non-refundable admin fee. And then, excuse me. And then here, cases with 2 or more parties, you can add another $200 to the fees shown above. So like, this is not a cheap adventure that you walk on, right? Like it can add up pretty significantly, but it is an option for people to pursue. So then lastly, here's the signature page, right? So this is an optional voluntary agreement. Read the arbitration disclosure on page 1. So again, page 1 is the disclosure. Page 2 is the actual agreement. Okay, so it's a 2-page documented transaction desk, but the first page is disclosure. The second one is a voluntary agreement. Okay, real property arbitration agreement for the property located at 123 Main Street. And so this, when you fill this out, this is all going to come in, and it's going to come in and simply state, well, we're in the city of. Whoops, I gotta get my text box. Let's pick on Baxter today for some reason. In the county of Crow Wing. I should have picked something I actually knew the zip code to. 56123, because that's all I can remember off the top of my head. And then the date of your purchase, the date of the purchase agreement, right? And then so that's going to be October 18th, 2021. Right. So then from here, you come in and you can say, so standard contractual language at the top side, identifying the property of which we're relating to, any dispute between the undersigned parties or any of them about or relating to the material facts affecting the use and enjoyment of the property, excluding disputes related to title issues. Remember, we already talked about that in the disclosure. Covered by this purchase agreement, dated the date that you wrote the agreement. Remember, so if you wrote it 2 days ago, but it got binding today, you would write, October 16th as an example. So this would be including claims of fraud, misrepresentation, warranty, or negligence, remember we talked about that earlier, shall be settled as specified in the arbitration disclosure above. National Center for Dispute Settlement, NCDS, shall be the arbitration service provider. The rules adopted by NCDS and the Minnesota Association shall govern the proceedings. The rules that shall govern the proceedings are those rules in effect at the time of the demand for arbitration is filed and include the rules specified in the arbitration disclosure on page 1. This agreement shall survive the delivery of the deed or contract for deed in the purchase agreement. So again, it goes beyond the date of closing. Again, you have that 2-year statute of limitations unless you want to extend if you can prove fraud. This agreement is only enforceable if all buyers, sellers, and licensees representing or assisting the buyers and sellers have agreed to arbitration as acknowledged by signatures below. So again, you've already agreed to it by being a realtor member. You've already agreed by our code of ethics saying that if we are summoned for arbitration, we shall be there, okay? So for the purpose of this agreement, the signature of one licensee of a broker shall bind the broker and all licensees. I give you full authority to sign this document if you feel it is best. I have your back. I will back you up in that entirety. And then we come down on this thing and you'll simply see very similar things that we always do, right? Seller, listing agent, buyer, buyer's agent. And then, of course, the residential real property agreement is a legal and binding contract between buyers, sellers, and licensee. If you desire legal advice, please consult an attorney. Okay. So that is the arbitration disclosure agreement. Again, disclosure on page 1, the agreement's on page 2. If you decide that this is what you want to do, you then follow all the terms outlined in this document, NCDS's, right? The agreement, so on and so forth, that walks you through this whole hunky-dory thing, okay? A little bit of the outline of the evidence that's there, what's going on, the process, interpretation. Oh, and then they actually attach the fee schedule in there. Look at that. Well done, Minnesota Realtors. And then you have their fee schedule located inside of there, and then a guide to real property arbitration for use in the state of Minnesota as published by NCDS. So you can walk through this pretty hefty document as well. I would recommend you probably read through this document. It is 20 pages. It's going to be super awesome reading, but it is important for you to understand what's in here. Again, you are not an attorney. You should not be giving legal advice, but you can guide your clients and answer questions that they may have based upon what you know about the NCDS document located in Transaction Desk. So that, ladies and gentlemen, is the disclosure statement and agreement for arbitration in real property. Questions? Look at that, it's 9:30. I did pretty good today. Normally I ramble.
So we don't have to have that even like if they decline it. Normally I just put a line through and put decline, but we don't even have to do that.
Nope. You're just wasting paper and your time. I mean, you can send it over if you want, but so the way I interpret this is if I don't get this form from a buyer, it tells me they're not interested in it. So even if I send one signed back, if they don't sign it, it doesn't matter. All they can do is take them to conciliation court at that point in time, or small claims court. Yeah, so it's not a requirement at all. You don't even have to write decline on it. You can, Perfect. But you don't have to. I find it to be a waste of time. Other questions?
Would you have like 2 minutes to run through how you present it?
Yes, I do, as I blow my nose. I'm so sorry. Hopefully you saw Lucas's face, not mine on that one. Yeah, so normally what I'm going to do, let me see if I have the purchase agreement in here just so I can show you. Let me add the PA real quick, and then I'll just run through my scripting on it. Because my scripting starts with the actual purchase agreement. Oh, there. Purchase agreement. Nope, not land. Purchase agreement. There we go. All right, so my script is usually going to start down at the last page of the PA. Nope, not wire fraud, right here. Okay. So after everybody signs and we do the whole thing, right? Then this is the whole section right here. Okay. So, hey, just so you guys know, right on lines 511, it says, I acknowledge that you've received the disclosure statement, arbitration disclosure, and real property arbitration agreement, which is optional, voluntary, and you do not have to sign it. However, I need you to acknowledge the fact that I've at least shown this to you, and I'm going to show it to you right now. Will you please sign this so we can move forward? Well, sure, we'll sign that form, Brandon. Fantastic. Now, let me walk you through what this actually means, okay? Are you guys familiar with arbitration? 99% of the time, people say, no, what is arbitration, Brandon? And I say, totally cool. Here's the basic bottom line of arbitration. Arbitration is you giving up your right to go to small claims court for anything over $15,000. So what this really means, though, is that if we come up with a major issue on the property here, you can, anything below $15,000, you can go to small claims court, you can file an appeal, you can figure out the whole situation. However, if something really big happens with this thing, right? The foundation buckles, the roof collapses, who knows what's going on here, right? We've had a home inspection. We've done our due diligence. We know a lot about it, but by living in a house a long time that new quirky things come up all the time with old homes, specifically as they age. And if these people we feel are dishonest anyway or negligent, okay, then arbitration would simply allow you to go after them, but then you have to pay a big fee. Some of them start around $600, $700, and they keep moving up there depending upon the size of the claim. So if you decide that you want arbitration, that's okay, but now you're leaving that decision in the hands of one person, and you don't have the ability to appeal that one decision if you don't agree or you don't think that it was handled justly and fairly. Now, I myself, every time that I buy a piece of property, I do not sign arbitration because I figure if there's a big enough problem, either we're going to work it out with the person, in a good Midwest mentality, or if they're really snotty and kind of a jerk about it, we'll take them to small claims court, or frankly, I'll just sue them and file a full case against them to receive restitution. So that's what I personally do. However, you guys have the total right to understand what you want here. If arbitration seems like a win to you and you think that's wise, that's okay. If you don't know, I would recommend you don't sign this. We can still move forward with the purchase agreement, but then contact an attorney for your best understanding. Do you guys feel like you would want to sign arbitration based upon what I've shared with you? Or would you like to not agree to arbitration at this point in time? And 90% of the time, they say, no, I don't want that. Sounds good. Then you don't need to sign this form because you've already acknowledged that you've seen it.
Okay. Awesome. Thank you.
Yeah, not a problem. Other questions? All right, my friends. Well, there it is. Coffee and contracts, which I know me and Amy had our coffee. The rest of you guys are kind of snobs and don't want to show me your beautiful faces, and that's fine. If there's a form that you would like us to cover next week on coffee and contracts, feel free to email me or text me, and we'll be happy to go over that. And of course, if something comes up between then and now, you can always reach out to me or save it for next week's coffee and contracts as we walk through it. I'm totally fine, by the way, just to reiterate, like if you have a contractual issue, right, that's going on, feel free to bring it up, because we all are going to learn from each other on how to handle these things. And the way I might do something is maybe not the way, that Mary's going to do something, right? And so we can have that conversation and try to figure out, because there's more than one way to sell real estate, right? That's why you all do it, because we all have our own unique way of handling and impacting people's lives through real estate. So thank you guys so much. Hope you have a great day. Happy selling. And I'm around if you need me. Appreciate you guys. We'll see you soon.
Thank you.